You're listening YouTube channel 3M Creator. I welcome all of you. Today we will go through lawyer's duty to his client in the words of Black Stone. Legal profession. Legal profession is a science which distinguishes the criterion of right and wrong, which teaches to establish the one and prevent, punish, or redress the other. The legal profession is the most independent one. A member of the legal profession never hesitates to condemn tyranny or injustice. A lawyer stands for justice more than a judge. A lawyer stands for justice more than a judge. He, as he pleads for it, it is a strong belief that the lawyers promote dispute and differences in the society. The work of the legal profession is not to create disputes, but settle the disputes whenever they arise. In fact, lawyers are peacemakers in the society. It is often said by other professionalists that the profession of law exploits the society and involves dishonesty and untruthfulness. Again, this is a wrong notion prevalent in the society for the simple reason that it is not the lawyer who practices, it is not the lawyer who practices dishonesty and untruthfulness. It is his client's compelling necessity which he approves by his art of advocacy and reasons. The change, the charge of insincerity and dishonesty against a lawyer disappears once it is realized that the advocate is engaged not in expressing his own views of the case, but he is presenting and marshalling or can be set of his client's view of it. Furthermore, legal profession is criticized that it does not add to the economic prosperity of a nation and consequently a lawyer is not an essential member of society. There is no doubt that it is peace which brings prosperity for a country, and peace is the result of law and the lawyers. Had there been no law and lawyers, there would have been chaos in society. However, the Indian lawyer is a role of a specialist. That is, he confined his occupational role to that of dispute processing in a court. The role, the role specificity of the Indian lawyer prompts him to prolong and perpetuate dispute processing. The reason is because they hardly have any other role to pick in, other role to pick on. The profession of law is noble calling. It is one of the most brilliant, learned, and attractive professions. It needs not only high depth of learning, but also a sense of social responsibility, which calls for a high and noble conduct. The noble, the legal profession is an important limb of the machinery for the administration of justice. Without the presence of a well-developed and organized profession of law, the court would not be in a position to administer justice. Law is a noble profession, but is also an elitist profession. Its ethics in practice, not in theory, though, leaves much to be desired. If viewed as a profession for the people, but law's nobility as a profession lasts only so long as the members maintain their commitment to integrity and service to the community. The profession of lawyers ordains a high level of ethics as much as in the means and in the ends. Justice cannot be attained without the state being pellucid throughout its course. And that is of great public concern, not merely professional care. The profession of law has been recognized as profession of high calling and of the noblest order since time immemorial. Neither is the legal profession a trade or a business, nor is an attorney a trader or a businessman. A lawyer has got to remember that he is expected to be a gentleman in the true sense of the term in every little or big act in his profession. In fact, no government can function without laws and without the services of the legal profession. In other words, legal profession is an honorable profession, as ancient as magistracy, as noble as virtue, and as necessary as justice. A lawyer and part of a learned profession has many obligations and duties of a honorable nature. It was not expected of a lawyer to bargain for any fee or to speculate on the result of a litigation so as to determine his fees. The contingent fee is an innovation of modern legal profession. The legal profession in India, which exists today, is the outcome of the legal system introduced by the British during of a lawyer to during the 18th century. The legal profession in India and elsewhere is largely a creation of statutes, though in some measures, customs, conventions, and uses also play an important role. It is therefore necessary to have an acquaintance with the legal framework in order to appreciate the provisions relating to professional ethics and professional responsibility which I wish to ideate by. Lawyer's duty to his client. In India, the lawyer's relation with his client are primarily a matter of contract. The relation is in the nature of agent and principal. The agreement determines to what extent the counsel can bind his client by his acts and statements, what shall be his remuneration, whether he will have a line on his client's prosperity, on his client's property, etc. It is evident, however, that as lawyer is also to conform to the ethical codes prescribed for him by law and usage. He cannot be a mere agent or mouthpiece of his client to carry out his biddings or biddings. His special responsibility rests on the members of the bar to see that the parties do not mislead the court by false, reckless statements on material matters. An advocate is not the servant of the client that engages him, but the true position is that he is the servant of justice itself. He is thus, in essence, a member of the body judicial, and hence it follows that he can commit no graver betrayal of his function than to deceive the court by means, direct or indirect. An advocate stands in a loco parentis towards the litigant. A member of the bar undoubtedly owes a duty to his client and must place before the court all that can fairly and reasonably be submitted on behalf of his client. It is the duty of an advocate to welcome his client in the chamber. The client must also not feel that his presence is unwanted. The advocate must give a patient hearing to the client and wherever necessary must make inquiries. He must reply to the client's letter and he must not hesitate to communicate to his client even an unfavorable result as promptly as one would like to communicate a favorable result. An advocate should treat his client with much importance and sincerity while giving opinions to the client. The counsel's duty is to act as a judge, responsible to God and man. He should advise sincerely and honestly to the best of his ability, though its consequences may be loss of prospective gain. If a pending dispute is likely to be settled either by the opponent's counsel or it is the desire of the presiding judge, the counsel must put all his sincere efforts without bringing any pressure on his client to bring about settlement. But if the client is ready to stand a risk and though he is advised settlement. He desires the case to be brought to an end. It is the duty of the advocate to do so to the best of his ability, skill, understanding, and legitimate means to bring about success. When the litigation ends, the lawyer should return the brief to the client, and he should not betray the confidence of the client even if he is not engaged in the appellate court. Though it will amount to repetition, it will not be out of place to make mention in that the relation between the advocate and the client is here of utmost good faith and confidence. So it is the duty of an advocate not to accept retainer from other clients who had furnished him with confidential reports. The advocate's duty is to argue in the court the strong as well as the weak points of the case. Fixation of fees is yet another duty. He shall fix such fees as is reasonable and justifiable. It is common practice that if the case is to be tried in a court or of place or different jurisdiction, the client would incur the expenses of conveyance. The advocate should not utilize this for meeting his own expenses. In the same way, the money received from the client other than fees and expenses for the purpose of procuring any document or proof shall be reasonable. Though Indian Vikaltanama, though Indian Vikaltanama form empowers the advocate to do all that is necessary, including compromise in the case, but it does not mean that, in view of the express authority's client's concern is undesirable. He should be prompt in communicating to the client the happenings of the court, reply to his queries and the result of the case, irrespective of the defeat or success. He should also act judiciously and wisely like a judge while handling the client's case. One must not forget that an advocate is a representative of the client and not an agent. After the case is over, it is the duty of the advocate to carefully return the brief to the client with all documents and certificates. After the case is over, it is the duty of the advocate to carefully return the brief to the client with all documents and certificates. The Bar Council of India has laid down the following duties of an advocate to his client. One is an advocate is bound to accept any brief in the court of tribunals or before any authority in or before which he professes to practice at a fee consistent with his standing at the bar and the nature of the case. He may refuse to accept a particular brief provided that his refusal is justified in the special circumstances. To which an advocate shall not ordinarily withdraw from engagements once accepted without sufficient cause and unless it is reasonable. Without sufficient cause and unless a reasonable and sufficient notice is given to the client upon his withdrawal from a case, he shall refund such part of the fee as has not been earned. Three is an advocate should not accept a brief or appear in a case in which he has reason to believe that he will be a witness, and if after being engaged in a case it becomes apparent that he is a witness, he should not continue to appear as an advocate. It is his duty to retire if he can without jeopardizing his client's interest. For an advocate should at the commencement of his engagement and during the continuance therefore make all such full and frank disclosures to his client relating to his connection with the parties and any interest in or about the controversy as are likely to affect his client's judgment in either engaging him or continuing the engagement. It shall be the duty of an advocate fearlessly to uphold the interest of his client by all fair and honorable means without regard to any unpleasant consequences to himself or any other. He shall defend a person accused of a crime regardless of his personal opinion as to the accused, bearing in mind that his loyalty is to the law, which requires that no man should be convicted without adequate evidence. An advocate appearing for the prosecution in a criminal trial shall so conduct the prosecution that it does not lead to conviction of the innocent. The suppression of material capable of establishing the innocence of the accused shall be scrupulously avoided. An advocate shall not directly or indirectly commit a breach of the obligations imposed by Section 126 of the Indian Evidence Act. An advocate shall not at any time be a party to fomenting of litigation. An advocate shall not act on the instruction of any person other than his client or his authorized agent. An advocate shall not stipulate for a fee contingent on the result of litigation or agree to share the proceeds thereof. An advocate shall not buy or traffic in or stipulate for or agree to receive any share or interest in any actionable claim. Nothing in this rule shall apply to stock, shares, and debentures or government security or to any instruments which are for the time being by law or custom negotiable or to any mercantile document or title to goods. An advocate shall not directly or indirectly bid for or purchase, either in his own name or in any other name, for his own benefit or for the benefit of any person, any property sold in the execution of a decree or order in any suit, appeal, or other proceeding in which he was in any way professionally engaged. This prohibition, however, does not prevent an advocate from bidding for or purchasing for his client any property which his client may himself legally paid for or purchase, provided the advocate is expressly authorized in writing in this behalf. An advocate shall not adjust fees payable to him by his client against his own personal liability to the client, which inability does not arise in the course of his employment as an advocate. An advocate shall not do anything whereby the abuses or takes advantage of the confidence reposed in him by his client. An advocate should keep accounts of the client's money entrusted to him, and the accounts should show the amounts received from the client or on his behalf, the expenses incurred for him, and the debits made on account of him with respective dates and all other necessary particulars. Where monies are received from or on account of a client, the entries in the accounts should contain a reference as to whether the amounts have been received for fees or expenses and during the course of the proceeding No advocate shall, except with the consent in writing of the client concerned, be at liberty to divert any portion of the expenses toward the fees. Where any amount is received or given to him on behalf of his client, the effect of such receipt must be intimated to the client as early as possible. Where the fees have been left unsettled, the advocate shall be entitled to deduct the advocate shall be entitled to deduct out of any money of the client remaining in hands at the termination of the proceeding for which he had been engaged, the fee payable under the rules of the courts in force for the time being, or by them settled and balanced, if any, shall be refunded to the client. After the termination of the proceeding, the advocate shall the advocate shall be at liberty to appropriate towards the settled fee due to him any sum remaining unexpended out of the amount paid or sent to him for expenses, or any amount that had come into his hands in that proceeding. A copy of the client's account should be furnished to him on demand, provided the necessary copying charge is paid. An advocate shall not enter into arrangements whereby funds in his hands are converted into loans. An advocate shall not lend money to his client for the purpose of any action or legal proceedings in which he is engaged by such client. An advocate who has at any time advised in connection with the institution of a suit, appeal or other matter, or has drawn pleadings or acted for a party, shall not act, appear or plead for the opposite party. Lastly, an advocate should never make use of any weak points. An advocate should never make use of any weak points or material facts of his former client for winning the case of another client. In all circumstances, the advocate should strive to earn the good faith and confidence of the client by his honest, sincere, and effective discharge of duties. Therefore, an effective, able, honest, and good advocate is the one who strictly adheres to above mentioned expectation in handling the case of a client. Lawyer's duty to the court. The cardinal principle which determines the privilege and responsibilities of advocate in relation to the court is that he is an officer of justice and friend of the court. This is his primary position. A conduct, therefore, which is unworthy of him as an officer of justice cannot be justified by stating that he did it as the agent of client. His status as an officer of justice does not mean that he is subordinate to the judge. It only means that he is an integral part of the machinery for the administration of justice. It is difficult to lay down any hard and fast rules as to what expression a lawyer can use with impunity while addressing the court and not should ordinarily be violated by it. An advocate has certain duties to the court and to the presiding judge irrespective of its success or failure of the case. One is duty to respect. The first and foremost duty of an advocate is to be always respectful to the court. The advocate must be bold, fearless, and independent in the court, and at the same time, he must not be disrespectful to the court and the judge. To his duty to attend the hearing. A legal practitioner should attend the hearing of the case throughout. He should not leave the court without the permission of the court to do so. An advocate has to attend to a number of hearings in a day and has to learn here and there. In this regard, he knows well which one of his cases in the case, which one of his cases in the cause list of a particular day is of utmost importance, requiring his personal attendance, and so he should act accordingly. Duty to receive judgment. If an advocate cannot be present personally to receive the judgment when it is being pronounced, he must at least arrange his representation in the court. Duty to assist the court. An advocate must not forget that his main duty is to assist the court in the right direction and to assist it to come to a right finding. The institution of a lawyer's profession has existed for, his, for this purpose only. Duty not to exhibit friendship. It is very bad of a lawyer to say to his client that the judge is this, the judge is his friend or familiar with him, and he will give weight to his argument, even if the judgment happens to be a very fast friend of a lawyer. He owes the duty not to exhibit his familiarity with the judge, and he must not take undue advantage of his personal relationship. Such advocates do not enjoy the confidence of the bar and much less eminence at the bar. Such tactics not only bring discredit to the lawyer but impair the dignity and impartiality of the judge. Duty to have good temper. The lawyer should never lose his temper in or outside the court in retortion of an adverse ruling or decision pronounced by the judge. Duty not to malign a judge. Never make a settlement which may directly or indirectly malign the great office of a judge. Never be a party to an accusation against a judge. On the contrary, a lawyer On the contrary, a lawyer should strongly put down such things which come to his notice. But this does not mean that a bona fide complaint against a judicial officer or judge should not be made. Duty not to mislead the court. A lawyer should win the confidence of the court and be trusted with the judge. For this purpose, an advocate should not cite a ruling which has been overruled or a statute already repealed and misguide the court. Duty not to interrupt the judge unless it becomes necessary to interrupt in the interest of justice. Duty not to cross the province of a lawyer. It means that the lawyer should not arrive at a decision in relation to a particular fact or law. It is the province of the judge to take initial notice. Duty not to interrupt the opponent every now and then during the course of his argument. Duty not to include a false pleading and file an affidavit which he knows to be false. An advocate shall, during the presentation of his case and while otherwise acting before a court, conduct himself with dignity and self-respect. He should not be. He shall not be so violent whenever there is proper ground or a serious complaint against a judicial officer. It shall be his right and duty to submit his grievance to proper authority. An advocate shall maintain towards the court's respectful attitude, bearing in mind the dignity of the judicial officer is essential for the arrival of a free community. An advocate shall not influence the decision of a court by any illegal or improper means. Private communication with a judge relating to a pending case are forbidden. An advocate shall use his best efforts to retain and prevent his client from resorting to sharp or unfair practices or from doing anything in relation to the court. Opposing counsel or parties which the advocate himself ought not to do. An advocate shall refuse to represent the client who persists in such improper conduct. He shall not consider himself a mere mouthpiece of the client and shall exercise his own judgment in the use of restrained language in correspondence, avoiding spurious attacks including and using intemperate language during arguments in court. An advocate shall appear in court at all times only in the prescribed dress, and his appearance shall always be presentable. An advocate shall not practice before a court, tribunal, or authority mentioned in Section 30 of the Advocates Act 1961, sitting alone or otherwise, with the sole or any member. Therefore, is related to the advocate as husband, father, grandfather, son, grandson, brother, father-in-law, son-in-law, brother-in-law, father-in-law, son-in-law, brother, uncle, nephew, first cousin, wife, mother, daughter, sister, mother-in-law, daughter-in-law, sister-in-law, aunt or niece, aunt or niece. An advocate shall not wear bands or gown in public places other than in courts except on such ceremonial occasions and at such places as the bar council or the court may prescribe. An advocate shall not appear in or before any court or tribunal or any other authority for or against an organization or an institution, society or corporation if he is a member of the executive committee of such organization or institution or society or corporation. Executive committee, by whatever name it may be called, shall include any committee or body of person which for the time being is vested with the general management of the affairs of the organization or institution, society or corporation. An advocate should not act or plead in any matter in which he is himself pecuniarily interested. For example, he should not act in a bankruptcy petition when he himself is also a creditor of the bankrupt, and he should not accept a brief from a company of which he is a director. An advocate shall not stand as a surety or certify the soundness of surety for his client required for the purpose of any legal proceedings. Lawyer's duty to the opponent counsel. An advocate shall not in any way communicate or negotiate upon the subject matter of controversy with any party represented by an advocate except through that advocate. He shall do his best to carry out all legitimate promises made to the opposite party, even though not reduced to writing or enforceable under the rules of the court. He should also always treat his opponent with fairness and due consideration. For instance, in drafting pleading, he should act with care, prudence, and good faith. He should not indulge in abuse and reckless charges of fraud, dishonesty, and criminality. This is for his own honor and reputation. He must satisfy himself that such allegations are irrelevant. He must satisfy himself that such allegations are relevant and can be supported by some evidence. The counsel should not take advantage of the temporary difficulties of the opponent, but should allow him the opportunity of putting up a fair fight. This he must do even if his client wishes him to do otherwise. It is the duty of an advocate that he should be fair to his professional opponent, counsel, and to his client. Give always due respect and importance to the opposite side advocate. He should not mislead his opposing counsel by concealing or withholding the facts. It should be a fair fighting between the intellectuals on professional battlegrounds. He should never degrade or pass degrading commands or pass degrading comments. Interruption, evidence, the arguments of the opponent's counsel should be avoided as far as possible. Baseless interruption will not speak high of the one who interrupts, as one would not like to be interrupted. One should not interrupt his opposing counsel. All the controversy in any matter lying between the counsel should be buried underneath the court, and the relation between them should not be affected outside the court. He should not make comments over the performance of the opponent counsel in the presence of clients of either side. In the same way, he should not laugh or show any gestures of mockery over the arguments of the opponent counsel in the court. An advocate shall not in any way communicate or negotiate upon the subject matter of controversy with any party represented by an advocate except through the advocate. Again, an advocate shall do his best to carry out all legitimate promises made to the opposite party, even though not reduced to writing or enforceable under the rules of the court. Over and above, the council engaged in the professional tussle should maintain the basic norms in bringing out the purpose and meaning of the profession. In this sense, an advocate shall never resort to cheap practice of meddling with the opponent's witness. It must be a fair fighting wherein he must prove his might be establishing might by establishing facts on his own credit, not by destroying the meritorious facts in the credit of the opponent's counsel. I thank all listeners, learners. Thank you very much.